Mrs. Jyotirmayi will introduce Ms. Manjusha.
Madam, friends, good morning to all. This is the second day of our International Workshop 2022 on Shape Your Future, Share Not Your Ideas. Today, our speaker is Manjusha Purinapalli from Bangor. Before going to listen her speech, some introduction about Manjusha ma'am. The profile summary of Manjusha ma'am is she done his MPhil in child rights, inside work experience in intellectual property law and child law. And the third one is court experience. She experienced research scholar, team leader, good in communication, interpersonal. And she has some skills and maintaining people's relations. Her commitment towards work and proactive in risk meditation. And the seventh one is effective time and priority management. And the next one is her academic proficiency. She done his MPhil from University of Wales, Bangor, North Wales, UK. And the second one is research on implementation of existing laws on child sexual abuse in India and drawbacks and socio-legal impact. And the fourth one is post-graduation. She done his post-graduation in University of Wales, Bangor, North Wales, UK. She done his LLM in Public International Law with specialization on Internet service providers in relation with the intellectual property rights. She done his graduation from Acharya Nagarjuna University, Vijayawada, Andhra Pradesh, India from 2007 to 2012. And next one is she done his BA LLB in intellectual property rights, international law, child law, law of banking and family law, environmental law, law of torts and law of contracts. Her additional certification. She done his legal secretary from in 2016. The next one is IT support certification program from in 2020. Microsoft Office 365 identities and requirements MS 100. The next one is Microsoft 365 fundamentals MS 900. ITIL Core Foundation, Microsoft Windows 10 MD 100, Compact TIA ITF Fundamentals. And her experience and training. She worked on internet service providers, focusing on copyrights and child rights and criminology. And the next one is she experienced court martials in Crown Court under the supervision of Walters. She worked on child abuse cases with a main focus on child sexual abuse with a critical analysis on the effectiveness of current laws regarding child abuse, providing with suggestions to improve the present scenario in India. Her management experience. Manjusha, founder and CEO of Yana Child Protection, non-profit organization in the best interest of child in India. She worked as a district project coordinator for NIRMAAN organization, team leader of 32 members, and conducting sessions on life skills and career guidance in 351 schools in Andhra Pradesh, India. She currently working as legal executive director in Royal Voluntary Services, Bangor, UK. Her academic achievements. She presented paper in National Seminar on Environmental and Sustainable Development in Acharya Nagarjuna University, Guntur, Andhra Pradesh. She conducted workshops on innovative in approaches to domestic violence against moving practice forward conducted by BASPCAN in London, United Kingdom. She presented paper regarding safeguarding children of Wales conducted by NSPCC in Cardiff, United Kingdom. She participated in workshops for improving outcomes for children and families, capacity to change conducted by NSPCC in UK. Thank you. This is about today's our speaker, Manjusha ma'am. Over to Manjusha ma'am. Ma'am, am I audible?
Yes, ma'am.
Okay.
Second. Am I audible to everyone?
Yes, madam.
Good morning, one and all. That was a lovely introduction by madam. Today we are going to discuss about intellectual property rights. But before that, I would like to thank one and all for giving me this opportunity, giving me the platform to share my ideas and my knowledge on intellectual property rights. This 1 week international workshop on Shape Your Future, Share Not Your Ideas is a wonderful platform. I thank the administration of Government Degree College, AVANIGADDA. I would especially thank going forward into the topic. Today we're going to discuss about intellectual property and patent rights. We'll be discussing about how intellectual properties are essential for us, why do we need intellectual property rights, what is patent rights, and some details about it. I was asked mainly to mention about how to protect your work, like your research and all. So we'll be discussing few pointers on how we can protect our work, how we can actually take advantage of intellectual property rights in protecting our work. So shall we move on into the main frame? I'm not sure if I'm audible.
Yes, madam. Yes, madam.
Okay. Clear గా ఉందండి.
Madam, you are very audible. You can continue.
Thank you, ma'am. So let us open a discussion into intellectual property rights. Today we'll be discussing about what is intellectual property rights.
Unmuted. Unmute లో ఉన్నాను సార్ అంటే మన వాయిస్ వినపడదు.
Patents and objectives. Law and legislation. What is an invention under Patent Act 2005 and basic understanding of intellectual property rights. Moving on to the first question. What is intellectual property? Property which comes from the human brain and for which government gives protection is called intellectual property. The different types of intellectual property rights are copyrights, patents, and trademarks. Today, we'll only be discussing about patent rights because that's what I was asked to introduce to you. In reality, the intellectual property rights are like a vast subject. 1 hour slot is a very, very small slot to explain all about intellectual property. So I have picked on patent rights because I was asked to introduce about the patent laws to you and how to protect your work when you're doing a research or when you're having some inventions. So moving on to further discussion, in wake of globalization, it is utmost important to be ahead of inventions and creativeness to compete the stiff competency in technology and trade. India is well recognized for its intellectual skills in the fields of software engineering, missile technology, moon, Jupiter mission, and other technology areas. However, we all find that India lags in generation of intellectual property right assets in terms of registered patents, industrial design, trademarks, etc. I found a recent report by US Chamber of Commerce, and India stood at 29th position among 30 countries in intellectual property index around the globe. I should say it is very alarming condition for policymakers as well as for nation as a whole. The development of any society directly depends on intellectual property rights and its policy framework. Unawareness among youth, academicians, and researchers, industrialists, and traders in India about intellectual property rights and its benefits is the main reason for lagging behind in IPR participation. Lack of IPR awareness resulted in the death of inventions, high risk of infringement, economic loss, and decline of an intellectual era in the country. Thus, there is a need for this talk because I would like to spread some awareness on intellectual property rights. There is definitely a dire need of dissemination of IPR information so as to boost indigenous inventions and developments in the field of research and technology. So, a basic question for you. How many of you are aware that we have IPR, intellectual property rights, or intellectual property, to be frank, in anything we find across? We watch movies, right? Movie names are being copyrighted. Songs are being copyrighted. The music that is made is trademarked. These are all intellectual property rights. We start our day with intellectual properties and we end our day with intellectual properties. Toothbrush, toothpaste, basic things and soap, face wash, whatever. They're all intellectually property rights because at some point they have been copyrighted, trademarked. You will get to know, once I move on to the next slides, I'll explain you more about it. I would like to give a brief description of law and legislation regarding what I'm talking about. Why do we need law and legislation for intellectual property rights? Why should we be having any of these rights at all or any of these laws in reality? Fact is, how are we being protected? We need these laws for a reason. We should be feeling protective. We don't need to know exactly what it is or why it is. For that reason, we have lawyers, patent lawyers, copyright lawyers. We have those people for doing it. But we need to know what law exists. It's always good to know. It's always good to have knowledge. So let's move on to the next slide. So as I said, intellectual property is a very vast subject. We can see on the screen, there are different types of intellectual properties which can be protected under law. We have got copyrights, inventions, patents, brand, trademark, protection, industrial, law, secrets, licensing, infringement. It's way too much. So let's not talk about all of that. We'll go bit by bit. For instance, today here we are about talking patents. If you see on the slide, what is a patent? Question mark, there you go. A patent is an exclusive right conferred by the government on an inventor to prevent others from exploiting the patent without his permission. We'll explain in detail. There you go. Patent is an intellectual property right granted to inventor by concerned government office for his novel technical invention. The term invention means solution of any problem in terms of development of a product or a process. I will enhance more on inventions in next slide. Among the different types of intellectual properties, patents are considered the most valuable and rightly so. I mentioned something about inventions. We'll be talking about inventions. Invention is a very regular word, isn't it? We all know what an invention is. Telugulo cheppalante kanipettatam. Inventing something. We'll talk about it later in the further slides. First, I would like to go with the law and legislation, as I mentioned earlier. All these laws are being protected by Indian Patent Act. In India, the grant of patent is governed by Patent Act 1970 and Rules 1972. The patents granted under the Act are operative in the whole of India, not just one state, whole of India. We can talk about a little bit of history of these laws and legislations. The history of patent law in India starts from 1911, very ancient, isn't it? When the Indian Patent and Designs Act 1911 was enacted, the present Patent Act 1970 came into force in the year 1972, amending and consolidating the existing law relating to patents in India. The Patents Act 1970 was again amended by the Patents Amendment Act 2005. See, as we see, there is a lot of amendment happening. That means we are changing with the world. We need more protection to what we invent. Wherein product patent was extended to all fields of technology, including food, drug, chemicals, and microorganisms. After the amendment, the provisions relating to exclusive market rights, EMRs we call them in general language, have been repealed. And a provision of enabling grant of compulsory license has been introduced. We will be talking about compulsory license to the end of the slides. It is important. The provisions relating to pre-grant and post-grant opposition have also been introduced. That means previously to the grant of patents and post to the grant of patents. We'll be discussing that in further slides. There you go. So here are some basic rules and regulations. I can just read them onto the slide for you. In India, patent rights are governed by the Patent Act 1970. At present, Third Amendment of Act, known as the Patent Amendment Act 2005, is working. For applications of Patent Act, rules are made by the government, which are known as Patent Rules 2003. As of now, Patent Amendment Rule 2006 and further update in September 2015 are in force. It's been constantly amending. You can Google these patent acts if you want to know further about any of these acts really. For better understanding of Act and rules, Draft Manual of Patent Practice and Procedure, MPPP, 2008 is made by the Patent Office. See, they've clearly mentioned for better understanding. The more we read into it, the better we understand. The better we understand, we can act on it. There are 4 patent offices in India, having work distributed according to their geographical location. We've got it in Kolkata, Delhi, Mumbai, and Chennai. We can access it. So now, what are the basic objectives of patent system? Why do we need a patent system? As mentioned, the objectives of patent system are to encourage inventions. There should be an invention. You know, if you are not appreciated, would you work? You wouldn't. So we need an encouragement to give up more inventions, you know, to produce more inventions, to breed inventions, to update industrial development, avoiding reinventing wheel. Once upon a time, there was Nokia 1100. When I was a student, I was using Nokia 1100. It was a big deal by then. But now we have Samsung, Apple, Galaxy, whatnot, everything. The phones are available for much cheaper prices. So there is always a scope of development. There is always a scope of development. So that is the reason we need to keep our patent system running with all new inventions and, breeding new inventions. There you go. Here is our next topic. As I said, I'll explain what is invention. So invention, as I said earlier, anything we invent, like any basic invention. But there are clear definitions for inventions under laws. It's not just a vague definition, but it is defined under the law itself. Section 21J of Patent Act 2005 defines the invention as a new product or as process involving an inventive step and capable of industrial application. Under the Act, new invention is defined under Section 211 of the Patents Act. New invention means any invention or technology which has not been anticipated by publication in any document or use in the country or elsewhere in the world before the date of filing of patent application with complete specification. That is, the subject matter has not fallen in public domain or that it does not form part of the state of art. There you go. Further on to inventions. According to the definition of new invention, Act talks of absolute novelty. That is, the invention should neither be used anywhere in the world or published in any part of the world. However, the later sections of the Act, for the purpose of anticipation and opposition proceeding, deals with the relative novelty, that is, not used in India or not published in any part of the world. Further, entire Act of Patent Acts refers to the word invention and not new invention. It's supposed to be invention. Therefore, for all purposes, relative novelty is criterion. So your invention must have novelty. That is when it is considered as invention. There are few inventions that can be patentable, and there are few inventions that are not patentable. Whatever we invent, it has to be having some good that is offering to the society. We cannot invent something that is not adding to the society, like antisocial things. We can't really patent those. And common sense would say those are wrong. So here is a slide that shows the difference between patentable and non-patentable inventions. I'll give you a minute. Please see the slide and I'll explain in a minute. So, what are patentable and non-patentable inventions? The patentability of any invention needs to fulfill the following criteria you're seeing on the slide. New compounds, new compositions, that means new formulas. A process for production of new compounds, new materials, new compositions. I've got three criteria mentioned here. One is usefulness, one is novelty, and one is non-obviousness. Usefulness is an invention must have industrial applicability and applied for practical purpose. It can't be impractical. Novelty. Invention must be new technology which has not been published or available in prior art of the country or elsewhere in the world before the date of patent filing. Non-obvious. Non-obvious, what do you understand by that? Invention which can be done by any ordinary skilled person is obvious and cannot be patentable. So if you have ordinary skilled person inventing something, that cannot be patentable. Hence, invention must not be obvious for patentability. It can't be too obvious. It has to be something new. It has to be of new components and compositions. It says that it should be unique, novel. So those can be patentable. And now we'll discuss on non-patentable inventions mentioned in the Act itself. The Act clearly mentioned under Section 3 of Patent Act 1970 that these following or these mentioned on the screen are not patentable. We'll see why. As mentioned, Section 3 of Patent Act 1970, the following are not patentable. Frivolous invention, invention against the natural laws, inventions which are not fair to health of human, animal, plant life, environment, as well as contrary to public order or morality. Discovery of any living thing, discovery of a non-living substance occurring in nature, formulation of any abstract theory, discovery of any scientific principle, substance or chemical obtained by mere admixture resulting in an aggression of the properties, mere arrangement or rearrangement of known devices. Invention relating to atomic energy and related to security of India are not patentable. As we said earlier, whatever we are inventing should be for the benefit of society and betterment of society. So law clearly mentioned those things that are not beneficial to society are not patentable. It's as simple as that. So in patenting process, at one hand, inventor is granted exclusive rights, which gives recognition as well as financial benefits. But on the other hand, inventor has to disclose all the relevant information in descriptive way. Mention this, descriptive way, to the patent office at the time of filing patent application. The information available in patent document can be seen by anybody, and no doubt it gives directions to other researchers to innovate further in the relevant field. That is it. Once we disclose what it is, people can get different ideas, like you can invent further. I can tell you an idea and you can take it further and prolong it. Same as previous example. Previously, the phones were of this size, flip model, like old phones, But these days, reinvented. It is still a phone, but look at the models, upgraded models. Oh, touch phone, got tablets, whatnot, everything, It's developed. So it's further inventions. So in India, Office of Controller General of Patents, Designs and Trademarks govern the patent registration process. As mentioned earlier, I'll be discussing about the registration process and how to file your application for patents in further slides. The office comes under Department of Industrial Policy and Promotion, Ministry of Commerce and Industry. So that will give you an idea on what is patentable and what is non-patentable inventions. Coming to how to patent your research. There you go. As we see on the slide, I'm going to discuss now on how to patent your research. Securing patent protection is one of the most important ways of safeguarding your intellectual assets. In order to succeed in and stay on top of the game, companies must distinguish themselves from their competitors based on their intellectual property portfolios. Patent protection stops your contenders from making, using, distributing, or importing your innovation in the country or countries in which patent rights are granted. Let us delve into world of patents and learn how effectively safeguard your intellectual property with the simple tips. These are the simple tips you can see on the screen itself. You should strike early by prioritizing patents. You can't wait forever. Oh, I'll patent it later. No, doesn't work. You have to patent it as soon as you finish your work. You should know what can be patented, for which the previous slide will help you. You will know what is patentable and what is non-patentable. And also you should conduct a pretty thorough research regarding your patents. Why you should conduct a patent search is, what if someone else has already invented what you are thinking to invent or what you have invented? That is your waste of time and resources. So you should always go through the basic search of what should be patented, what you can do, what work is available, for your inventions. Sometimes we might think, oh, I'm genius. There you go, I got this thought. But the problem is human brain. Everyone thinks. No one stops thinking in reality. So someone might have already thought about the same idea and already been patented. So it's good to know. Don't waste your time. Don't waste your resources. So always be ahead of the game. And then you should choose the type of patent protection you need. There are several types of patent protection, which will be discussed in further slides as well. And also, you should draft a properly perfect patent application. I would say drafting a patent application might be a bit tough or complicated when we do it ourselves. So they always choose, though it is expensive, but we choose lawyers to do that because they're aware of law more than what general public are. So drafting a patent application is a big deal, which we'll be discussing in further slides too. As we mentioned earlier in slide, there are different patent applications. So here are some of those, which is ordinary application, convention application, and PCT national phase application. Most people who are applying for patents go with the PCT national phase application. I would explain a little bit on PCT. It's called Patent Cooperation Treaty. We'll go on that. The patents are territorial rights. Therefore, applicant has to apply patent application to patent offices of different countries individually. This practice requires huge amount of investment, time, and energy. In the same pattern, Patent Cooperation Treaty, which we mentioned here as PCT National Phase Application, concluded in 1970, provided a facility to file a single international patent application instead of filing several separate national or regional patent application. So now you understand why people don't go for ordinary application and convention application, and they choose to go for PCT national phase. You like to get things done easily and properly. If you have to do it in every region, that's costing you more money. Every nation, that's costing you more money, right? So if we go to the PCT national phase application, it's going to have a single application. What are they mentioning? To file a single international patent application instead of filing several separate national or regional patent applications. Clear? Although granting of patent remains under the national or regional patents, authorities of various PCT member nations, but applicant can get priority date for first filing applicable in the member countries which are more than 145 in number with a single patent application. That sounds nice. So probably that's the reason people want to go with the PCT national phase application. Go. Moving on to the next one is, there you go, pointers to draft patent application. As mentioned before, we can draft our own patent application, but people prefer to go to patent lawyers, copyright lawyers. Lawyers can do better work regarding the application because they can't go wrong. They have done several applications prior to your application, so it would always be good to have that experience added to your application. So here are some pointers. First, we'll discuss about the title of the application, background and summary of your invention, abstract and drawings. Coming from the science, maths fields, abstracts, drawings are priority. Elaborate those explanations of designs and drawings, patent claims, and cross-reference to related applications. Cross-referencing to related applications, I would say, you might have read books, textbooks. See, under the textbooks, you will find referencing, footnotes we call them. That means you are doing your work, taking into consideration and referring to someone else's work. It is legally okay because you are mentioning their work. You're not just, fly passing their work. Someone already has done some work. In the research field, you are doing some work. So you can take points from them, but you have to mention. That's the reason we have pointers, like footnotes. You will see in any textbook, really. And then coming to the important bit, patent filing procedure. How do we file patent in India? I'll give you a minute to go through the screen I'm sharing now, because that is the flow chart precisely for filing patents in India. So, steps for application of patent. How are we going to put an application through? You can choose to apply for a patent all by yourself or take help from registered agents, whom we call lawyers. When it comes to the cost of getting a patent, the following two elements come into the picture. It is expensive. Government fees for forms and renewals, which is compulsory. If you choose to have an agent or a lawyer, then the charges of the professional will be included. It is always recommended to get a patent through the registered agent. As I explained before, they've got their experience that will add up to your application. And here are the steps how to apply for patent. We'll discuss in detail. So I'll go with step 1. Invention disclosure. The first step is to disclose your invention to the professional. This is done by signing a non-disclosure agreement. It is always recommended to submit each known fact about your invention and do not withhold any information back, because anything you hold back can cause your application in refusal, which we don't want. We'll be spending a lot of money on it and time on it. We don't want the application to fail. So we need to be really careful in giving all the details onto the non-disclosure form. Step 2 is patentability search. Usually, a professional charges fees at this step, say like 10,000 to 20,000 rupees approximately. And these are the rates I'm saying like 2 years back. So after COVID, I don't know. I might have to further research on what they're going to charge now, but it is expected to be between 10,000 rupees and 20,000 rupees. At this stage, your professional performs extensive research for prior evidence in all the possible databases. So as I said before, patent search, the lawyer will do that for you. He will search if this work you're submitting with the non-disclosure is patentable or not, which reduces your burden and stress. Further, we can build a patentability search report based on your invention. So they will produce you with a certificate that this is patentable. You know, that itself shows that the application is going further and it's not being rejected. So that is an important step, patentability search. Coming to the third step, decision to file an application for patent. This is where the actual process begins. So till now what we did was just seeing if the work is to be patentable or not, and invention disclosure certificates, something like that. So it's just pre-work. So this is the main bit. Decision to file an application for patent. So after detailed research, which will give us a certificate in the earlier step, existing history to your invention, you can decide if you want to go ahead with the patent application filing. So here is where you decide if you want to go forward or not with the application of patent filing. Your invention must definitely have an inventive step as compared with prior art pieces to qualify for your patent. Ante, whatever you have before, you need to be adding something to it. That should be your invention or innovation. So always make sure that you have an inventive step in the work you are applying for patent. The step where you decide to go ahead with the filing process by writing an application is called patent drafting. So before even applying for patent, you need to draft an application. That is main bit, right? So what is patent drafting? You can choose to draft an application on your own or take a professional's help to do this. If you choose to take help, you might have to pay somewhere around 20,000 to 30,000 because professionals do charge, but you get good work and your application will be going forward without any problem. So always prefer a professional work than to what we apply for, because it's your lifetime work that you want to patent. You don't want to go wrong in it. So always choose for the betterment. And if you want to file a patent application in a prescribed manner with appropriate forms, as I mentioned earlier, government forms with fees, we need to pay 1,600, 4,000 or 8,000 based on the type of application. We mentioned earlier the types of application: ordinary application, conventional application, and PCT application. So depending on the application you want to go through, the price varies. First one is 16,000, next one is 4,000, and the PCT one is 8,000. While submitting the patent application in the patent office, if you do not file a request for early publication, the patent application will be published on expiry of 18 months. See, on the slide you can see the process between filing and publication is 18 months. So it is a time-taking one. It is an expensive one, but patent filing is important to protect your work. So then we come back to the step of filing the patent application. Oops. Oh, there you go. So we come back to filing the patent application. After you're done with a review of your patent draft and are satisfied with the scope and details, you're ready to file for an application. Then we move on to request for examination. In this step, where the applicant is required to request the Indian Patent Office to examine your patent application within 48 hours. Request for examination fees ranges from 4,000 to 20,000. So you are requesting Indian Patent Office to examine your application, and that will cost you as well. So it will be like 4,000 if you are doing an ordinary application, and depending on the application you choose, like PCT, it will be up to 20,000, and it also depends on the professional you're choosing to do your application. So after the request for examination, you will be responding to the objections. Sometimes people can object your work, saying that this is harmful to the society, this is not useful to the society, this is causing a negative impact on society. So I object your patent filing, I object your application. People always do that. So if the application meets the prescribed requirements, it is placed in order for the grant. Usually the final grant of application is notified through a journal that is published. You might all have known that we have like regular journals for patents, trademarks, copyrights, and almost all intellectual property rights do have journals that are regularly being printed, say quarterly or something. So if your application is granted, it will be in the journal and you will be notified through the journal. So that's how you get a grant of patent. If application meets, you'll get it through the journal. Previously, we spoke about compulsory licenses. What is a compulsory license and why should we have a compulsory license? Usually, a patent is in force for 20 years. So once this application has been granted, that means the work, your work is patented for 20 years. So anyone like using or redoing or any reference to your work, you'll be getting paid. Your work is protected. So it lasts for 20 years, and on completion of 20 years, the owner is required to renew the patent by paying a small fees. Probably at that point, it won't be all this expensive, paying 20,000 to this, 20,000 to that. It won't be that much. So once your work is already 20 years finished, you'll be renewing it with a very, very small fees. So depending on we will be talking about the compulsory licenses now, which will give you an idea. Oh, there you go. The patent acts give monopoly to inventor to harvest financial gains for invention, but contrary in case of national emergency, as per Section 92 of Patent Act 1970. Government can issue compulsory licenses to third party for non-commercial use of public. Besides, these when authorized patent owners is not fulfilling the demand of society by will or unable to produce the patentable product or such in case of drugs, food, medical equipment, vaccination, life-saving equipment, etc., the government is fully authorized to allow somebody else to produce patentable product by giving compulsory license. So in this case, government is liable to pay fair justifiable economic benefit to patent owner. So there are some licenses that can actually revoke your patents and government can use it for the betterment of society. So they can pay you the money back, some sort, but they'll use it for the betterment of society. So this is where compulsory licenses come in place. So why should we go through all this process, spending money? It's too much money, right? I was saying 20,000, 8,000 here, 4,000 there. It's a lot of money, isn't it? So you are inventing something. It's your invention, but you have to pay to protect it. Why? Why do you need a patent registration? So this slide on the screen, I would like to explain what are the benefits of patent registration. If we are doing something, we expect some benefit out of it, don't we? Anything really. We go to a theater, we would like to have a free popcorn, don't we? This is also something like that. So the benefits of patent registration. So it prevents theft of your invention, provides intellectual property rights, helps you in earning from your own invention, creates an asset for you and your enterprise, and safeguards your invention for a time period of 20 years. So these are like known benefits of registering your patent. If you don't register your patent, you won't get any of these benefits. And it is your work. So you need to be protecting it. So some more key pointers on benefits of patent registration. It prevents theft of your invention, the freedom of exclusivity, easy to build a merchandise and commercialize, higher market share since your idea becomes a brand, more monetary value and high profit margins. So these are some more benefits that are not mentioned on the slide on the registration of patent. Although the entire process of filing a patent is long and complex, as I said, you have to wait 18 months there, sometime here, lot of money. So this is a very long and complex process. This is not easy process, filing a patent application. One must remember the importance of why we should register. With digital advancement, it is probable that the process might get simplified and easy. Having a patent in place ensures that no individual can claim rights over your invention. If at all there happens to be an infringement, you can take help from legal bodies and avoid the problem that can prove to be a hurdle in the growth. See, here I would like to explain whatever the process I am saying could sound difficult today, but it could get a lot easier tomorrow. I was mentioned that I'm giving the talk to BSc students, am I right? I was mentioned most of you are like BSc students. Am I audible? Okay. Hello. Okay, no worries. So once upon a time, things were hard. When we were students, when I was doing my undergraduate law, there wasn't so much scope for any of this. We didn't know what patents were. We didn't know anything. We were just like, okay, whatever. I would like to pass the exam. Done. Finish. I'm not interested in it. But once I got the interest in patents, that was incredible. Whatever I see, I like to find how is this an intellectual property? What is it protected with? What could be the thing in it? You know, is it trademarked, copyrighted, patented? It could be any. So I got the interest in finding things in it. It is all of interest. As I mentioned, the process of this patent registration could sound complicated now, expensive now, but it could get a lot easier later on. Back in days, when you have to type a message, you only have 9 digits and you have to press every digit 4 times to get the alphabet. But now, touch screen, voice, you can just type messages by saying it into the phone. You can say, okay, Google, give me this. Okay, Google, give me that. Play this song, play this music. It became a lot easier, isn't it? So definitely, these patent registration processes will get much easier and much cheaper in the ongoing periods. Who knows, it could be a lot cheaper as well, we never know. So last but not least, we'll be into the last phase of patent infringement. So after doing all this, someone can still steal your work. Say, for example, how many of you are aware of YouTube, Instagram, something like that? You're all on it, aren't you? Selfies, reels, filters. Excited, right? So sometimes when you put a video or a content, there will be a ban on you. Have you ever noticed it? ఆ బ్యాన్ ఎందుకు పడుతుంది అని మనం ఆలోచించమ్మా. It is relevant with intellectual properties. Means someone is stealing your work or you are stealing someone else's work. That is when you get a ban. Some reels are deleted. ఇప్పుడు కొత్త కొత్త సినిమా పాటలు వస్తాయి, దానికి మీరు వీడియో చేస్తారు. ఆ వీడియో ఒక్కొక్కసారి తీసేస్తాడు. ఎందుకు తీసేస్తారు? ఆ మ్యూజిక్ తయారు చేసిన వాళ్ళకి మనం లైసెన్స్ పే చేయకుండా ఆ మ్యూజిక్ వాడి దానిలో మనం వీడియో చేస్తున్నాం కాబట్టి దాన్ని డిలీట్ చేసేస్తున్నారు. సో మనకి తెలుసో తెలియకో వేర్ ఆల్వేస్ బీన్ ఎ పార్ట్ ఆఫ్ ఇంటెలెక్చువల్ ప్రాపర్టీ. మన చుట్టూ ఎప్పుడు ఉంది. ఇట్స్ ఆల్వేస్ బీన్ దేర్. మూవీస్ చూస్తున్నాం కదా, ద టైటిల్స్ ఆర్ రిజిస్టర్డ్, కాపీరైటెడ్. మనం చూడట్లా, మనం తెలుసుకోవట్లా, జస్ట్ మనం ఎంటర్టైన్మెంట్ ఫీల్ అవుతున్నా, అయిపోయింది. రైట్? వీఆర్ నాట్ యాక్చువల్లీ ఫోకసింగ్ ఆన్ వాట్ ఇట్ ఈస్. తెలుసుకుంటే ఇట్ విల్ బి మోర్ ఇంట్రెస్టింగ్. నాట్ జస్ట్ మూవీస్, మనకి సాంగ్స్, ఆల్బమ్స్, ఎనీథింగ్ అన్ని పేటెంటెడ్. ఈవెన్ వాట్ వీఆర్ యూజింగ్, సెల్ ఫోన్స్, ద లోగో బిహైండ్ యువర్ సెల్ ఫోన్, యాపిల్, సామ్సంగ్, ఇంకా వేరేవైతే సెల్ ఫోన్స్ ఉన్నాయో అవన్నీ కూడా రిజిస్టర్డ్, ట్రేడ్ మార్క్డ్. దోస్ లోగోస్ కాంట్ బి యూస్డ్ బై ఎనీవన్ ఎల్స్. దే హ్యావ్ సెపరేట్ లోగోస్ అండ్ ఎవ్రీథింగ్ ఈస్ దేర్. మనకి జియోగ్రాఫికల్ గా కూడా కొన్ని ఉన్నాయి. తిరుపతి లడ్డు, తిరుపతి అనేది ఊరు పేరు, ఇట్స్ ఎ ప్లేస్, జియోగ్రాఫికల్ ప్లేస్. అది దానికి ఉన్న ఐడెంటిఫికేషన్ ఏంటి? ప్రసాదం, లడ్డు. యూ కెన్ గెట్ ఇట్ ఓన్లీ ఇన్ తిరుపతి. సో అది దానికి ఉన్న జియోగ్రాఫికల్ ఇంపార్టెన్స్. దట్ ఈస్ లైసెన్స్. అది కూడా ఇంటెలెక్చువల్ ప్రాపర్టీయే. సో ఇఫ్ వి గో త్రూ ఇట్, we've got so many, right? Place names తో ఉన్న చాలా ప్రాపర్టీస్ ఉన్నాయి. హౌ ఐ కాల్, అదేంటి, షోలాపూర్ చెప్పులు, స్లిప్పర్స్. షోలాపూర్ ఎక్కడిది? ప్లేస్ నేమ్. బందర్ లడ్డు, అవనిగడ్డ బందరేనా? సి, we all have intellectual properties right around us. మన చుట్టూ ఉన్నాయి. We just have to identify them. Make life simple, make life easy. తెలుసుకుంటే తప్పేముంది? సో ఇప్పుడు ఇన్ఫ్రింజ్మెంట్ అనే మాట మనం యూజ్ చేసాం. సో వాట్ ఈజ్ ఇన్ఫ్రింజ్మెంట్? పేటెంట్స్ ఎలా ఇన్ఫ్రింజ్ అవుతాయి, దానికి లీగల్ రెమెడీస్ ఏంటి? As you see on this slide, if any person exercises the exclusive right of the patent holder without permission within the country of patent grant and during the patent term, మనం పేటెంట్ టర్మ్ 20 years అని చెప్పుకున్నాం కదా, ఆ 20 years లో వితౌట్ పర్మిషన్ గనక ఒక పర్సన్స్ పేటెంట్ మనం యూజ్ చేసుకుంటే దట్ ఈస్ పేటెంట్ ఇన్ఫ్రింజ్మెంట్. దట్ మీన్స్ వీఆర్ ఇన్ఫ్రింజింగ్ దేర్ రైట్. A person is liable for infringement in his product or process is same as patented invention. So we will be liable under court. మనం లా ద్వారా పనిషబుల్ ఇఫ్ వి డూ అన్ ఇన్ఫ్రింజ్మెంట్. అది మనం అంతగా చూడం, ఎందుకంటే వీడియో డిలీట్ చేయగానే అయిపోయిందిలే, పోతే పోయిందిలే అనుకుంటున్నాం. నో, యూ హ్యావ్ యాక్చువల్లీ ఇన్ఫ్రింజ్డ్ సంథింగ్. దెర్ ఈస్ ఆల్ రైట్స్ దట్ వాళ్ళు మన మీద కేసు వేయొచ్చు. బట్ మోస్ట్ కేసెస్ లో ఏంటంటే ఇట్ ఈస్ ఎ లెంగ్తీ ప్రాసెస్. ఫైలింగ్ ఎంత లెంగ్తీ ప్రాసెస్, ఇన్ఫ్రింజ్మెంట్ కున్న లీగల్ రెమెడీస్ కూడా అంతే లెంగ్తీ ప్రాసెస్. సో దే డోంట్, వాళ్ళు చేయట్లేదు కదా అని మనం తప్పు చేయకూడదు కదా. సో వీ హ్యావ్ టు నో వాట్ ఈస్ ఇన్ఫ్రింజ్మెంట్. సో ఇక్కడ ఐ హ్యావ్ గివెన్ యూ ఫ్లో చార్ట్. పేటెంట్ ఇన్ఫ్రింజ్మెంట్ లో 2 రకాలు ఉన్నాయి: డైరెక్ట్ ఇన్ఫ్రింజ్మెంట్, ఇండైరెక్ట్ ఇన్ఫ్రింజ్మెంట్. Indirect infringement, we have literal infringement, equivalence infringement, and in indirect we have contributory infringement and infringement by inducement. Words anni konచెం harsh ga undochu. These are all legal terms, andike they sound very odd. I can give you a little explanation on the infringement according to the act itself. Section 48 of Patent Acts 1970 grants the following rights to the patentee. Patentee ante the one who have applied for patent. In case of the product patent, the following sections would amount to infringement. See, like making, using, offering the sale, selling, or importing of these purposes the product in India without permission of the patentee. That is patent infringement. In case of process patent, the following would amount to infringement. Again, same, using, offering, selling, importing, these are all coming under infringement. Types, as we mentioned, direct infringement we have literal and equivalence. Direct infringement, which is most apparent and common type of infringement. In this type, which includes marketing, sales, commercial use of an exact patented item or invention that performs substantially identical function. Direct infringement may literal or non-literal, also known as doctrine of equivalence. Literal infringement occurs when each and every component in the patent specification has been used in the alleged infringing product or device or process, while non-literal infringement occurs when the infringing device or process may be similar to equivalent or the claimed invention. Coming to indirect infringement, it is when the infringement does happen, but the direct infringement is facilitated by someone. Direct kaadu, indirect. Indirect infringements are also two types. As we mentioned, contributory and by inducement. So remedies. What are the remedies in case of infringement? Legal remedies అనగానే మనకి సినిమాలో చూపించినట్టు హాఫ్ మినిట్లో అయిపోవు. They take a very, very long process. In reality, చాలా లాంగ్ ప్రాసెస్. మనకి చాలా సివిల్ కేసెస్, క్రిమినల్ కేసెస్ చూస్తూ ఉంటారు కదా. Civil cases take like for years. There are few cases that are still ongoing for 40 years, 50 years. Civil cases ante. Anything relevant to patent, civil kindoku vastundi. So it will take time. Legal remedies are very lengthy. Indian Patent Act lo section 108 lo they have been mentioned about legal remedies. Ante మీ యొక్క patents గనక infringe అయి ఉంటే మీకున్న legal support ఏంటి? So, Section 108 of the Patent Act 1970 provides the relief which a court may grant in any suit for infringement, including injunction, subject to such terms, if any, as the court thinks fit or damages or any account of profits. An order of delivery or destruction of infringers article may also be passed. So, there is a destruction. The court may also have order which are found to be infringing and materials are implements, the predominant use of which is the creation of infringing goods. They shall be seized, forfeited, and destroyed, as the court seems fit under the circumstances of the case, without the payment of any compensation. So, compensation ఇవ్వకపోగా they will destroy the goods. అంటే ప్రతిసారి compensation ఇవ్వాలని రూల్ లేదు. They can actually destroy the goods that have been created by infringement. సో దానివల్ల బెనిఫిట్ ఉండదు, అలానే లాస్ ఉండదు, which is fine, maybe. Although Indian IP law is thorough and generally comparable with European IP laws, there are still significant concerns over IP enforcement. A major cause for concern is enforcement, which is bureaucratic delay with a backlog of cases at both civil and criminal courts. This means that case can run for 5 years or more. There is also a lack of transparency, particularly at local level. A significant feature of the IP environment in India is the large number of small players infringing IP rights. This means seizures tend to be small, which requires a substantive and financially draining effort in order to make an impact. Manam endaka anukunnade. Legal remedies will take time. Even the law is mentioned that it can take up to 5 years or more. Chinna, what they mentioned properly is small players making big difference. ఇప్పుడు ప్రతి చిన్నదాని మీద మనం కంప్లైంట్లు వేసుకుంటూ వెళ్తే ఇట్స్ గోనా టేక్ లాంగ్ టైమ్. ఆబ్వియస్లీ లైన్ విల్ బిల్డ్ అప్, చాలా కేసెస్ పైల్ అవుతాయి, విచ్ ఇస్ ఆల్రెడీ అ ప్రాబ్లమ్ ఇన్ ఇండియా. లీగల్ కేసెస్ ఆర్ పైల్డ్ అప్ సో బ్యాడ్, జస్టిస్ ఈస్ బిన్ డిలేడ్. జస్టిస్ డిలే అయ్యే కొద్దీ కేసు మీద ఇంట్రెస్ట్ పోతుంది. ఎంతమంది ఫైనాన్షియల్ గా ఎఫర్ట్ చేయగలరు? ఎఫర్ట్ చేయలేరు. ఇట్స్ ఎ ప్రాబ్లమ్. సో వీ నీడ్ టు థింక్ అబౌట్ ఇట్. అది ఒక డ్రాబ్యాక్. యాక్చువల్లీ పేటెంట్ యాక్ట్ లోనే ఉన్న డ్రాబ్యాక్. మన ఇండియన్ కోర్ట్ సిస్టమ్ కొంచెం బెటర్ అయ్యి, it can dispose cases off quickly and give judgments quickly. There can be a possibility of finding remedies quicker. So coming to this, we'll finalize with a conclusion. In knowledge-based economy, intellectual property rights are very much essential for progressive societal development. The IPR is basic necessity to be part of local as well as global competitive trade, as without dissemination of IPR knowledge and implementation. Creating the innovation environment is really important. No doubt that India and other developing countries will definitely harness its proportion share in global trade by exploration in intellectual property rights. So as we mentioned, if we can better the legal system, the process of legal system, there can be a betterment of patent acts being properly imposed. So that's me. Thank you so much. Thank you so much for the time and attention. I would like to thank Sanjay Sri Garu for giving me this opportunity. Thank you very much.